I just finished voice recording a motion in the Delete Laws v. Wagner et al. In Ohio, and some items dropped on Floyd Wallace's case in Las Vegas, and one of them in particular is extremely interesting. So I think it's going to be the first one that I'm going to drop as a video. You might have to wait for the others. There's also a motion to dismiss on Wallace's case, but let's go through this motion. So it's the Floyd Wallace case v. Las Vegas and the whole of the state of Nevada. Defendant LVMPD's motion to preclude Jose Decastro from practicing law without a license and to strike plaintiff's complaint as an improperly filed pleading. You did hear that right. Jose Decastro mentioned in Floyd Wallace's case. Defendant Las Vegas Metropolitan Police Department, by and through their attorneys of record, Marquis Urbach, hereby file their motion to preclude Jose Decastro from practicing law without a license and to strike the plaintiff's complaint as an improperly filed pleading. This motion is made and based on the attached memoranda and points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. Memorandum, points and authorities. 1. Introduction. The case arises out of an incident between Plaintiff Floyd Wallace, a named First Amendment auditor, and several LVMPD officers, which occurred on May 10, 2023. On that date, plaintiff went to the employee parking lot of LVMPD's Spring Valley Command Substation, located at 8445 Eldora Avenue, Las Vegas, Nevada, 89117, to record vehicles entering a gate marked police personnel only. Plaintiff would not only record the vehicles, but would also walk right up to the gate while it was open. Plaintiff knew he was filming a restricted area because it was obvious based on the sign. Also concerning was the fact that plaintiff had his face covered with a mask. The officers found plaintiff's behaviour suspicious. Not only was plaintiff wearing what appeared to be a ski mask, but he was also wearing glasses and a red hoodie in May in Las Vegas. When someone asked plaintiff what he was doing, he refused to answer. Due to plaintiff's suspicious behaviour, police officers detained plaintiff on reasonable suspicion. Thereafter, plaintiff was arrested for attempted trespass and searched. As a result of this arrest, plaintiff filed the subject complaint on May 24, 2023, that should be. Concurrent with this motion, defendant LVMPD is filing a motion to dismiss this complaint. This motion seeks to address the fact that non-attorney Jose Decastro, another First Amendment auditor, is drafting plaintiff's pleadings and directing this litigation. Decastro is also suing LVMPD. Plaintiff's complaint is almost identical to the complaint filed by Decastro, in which both complaints incorporate the exact same causes of action, language, and even typos. Thus, LVMPD feels compelled to file this instant motion to preclude Decastro from engaging in the unauthorised practice of law in the future. 2. Statement of facts. A. Decastro has clearly assisted plaintiff in the preparation, drafting and filing of his complaint against the LVMPD defendants. Comparing both complaints side by side, it is obvious Decastro has engaged in the unauthorised practice of law by assisting plaintiff in the drafting and filing his complaint against LVMPD, and plaintiff has only switched out some of the facts alleged in the complaint to fit his own narrative. The glaring similarities between the two complaints are illustrated side by side in the table below. Decastro's complaint says, I, plaintiff, a member of the press who specifically records police interactions, was recording a police interaction outside of a Rolling Smoke barbecue in southwest Las Vegas. Plaintiff's complaint read, I, plaintiff, a black member of the press who specifically records police interactions, was recording a police officer interaction outside of the Spring Valley Command Substation in southwest Las Vegas, Nevada. Second item is, Decastro's complaint. Sadly, the abusive treatment of plaintiff endured for merely asserting his rights and recording the police is not unusual or surprising. This civil rights action seeks to vindicate plaintiffs' constitutional and statutory rights and hold the officers and the department accountable for biased policing practices and the policies or absence of policies that resulted in these practices. And Floyd's one is copied verbatim. Next bit. The party section list out plaintiff Decastro and defendants LVMPD, the state of Nevada, and the officers involved in that specific incident. And in Wallace's, plaintiff's party section is almost identical, only switching out the names of the officers involved in this incident. Next one. And this is being copied verbatim. This court has jurisdiction over this action pursuant to 28 U.S.C. 1331 and 1343A34 because it arises under the Constitution and laws of the United States as it is being brought to obtain compensatory and punitive damages for the deprivation under colour of state law of the rights of a citizen of the United States of that are secured by the United States Constitution pursuant to 42 U.S.C. 1981, 1983 and 1988. This court has supplemental jurisdiction over the claims arising under Nevada law pursuant to shit. Oh, shit. I'm going to leave that in. I just smashed my mug. Oh, well. I don't know where I got up to. But it's all verbatim, so I'll do the next paragraph. This court is the proper venue pursuant to 28 U.S.C. 1391b2 because the events giving rise to the claims occurring in the county of Clark in Nevada, which is in the U.S. District of Nevada. Right, on to the next one. As a result of the defendant's actions, plaintiff suffered a deprivation of his rights and liberty, sustained physical injuries and suffered physical pain, mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. And Wallace's is, as a result of the defendant's actions, plaintiff suffered a deprivation of his rights and liberties, suffered mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. Next one's copied verbatim. I won't read these all out because it's going to be a bit repetitive, but basically they're showing side by side that there's lots of similarities between the two cases. I'm adding a bit to my original recording because I just want to draw specific attention to these court notes. The court should note that even the sporadic placement of the apostrophes in this section are the same in both complaints. The court should note that the eighth cause of action is misspelled AIGTH in both complaints. Right. In addition to the evident similarities between the two complaints, Decastro has openly spoken about plaintiff's case on his YouTube channel, Delete Laws, where he said that he wanted to send a real quick message to the Las Vegas Metro Police Department. The federal civil rights lawsuit continues, and you will be held accountable for wrongly arresting Mr. Floyd Wallace. Decastro adamantly stated his distaste for police officers, stating Las Vegas Metro Police Department has got to understand you will not arrest journalists, and if you do, I will be damn sure that you are held accountable for what you do to people. Decastro further indicated him and Wallace did an audit together, which was kind of nice because it was nice to have someone that was unafraid of these rat boot thug pigs. Decastro claims to have helped Wallace raise the funds to file his lawsuit because during his video he was given a big thank you to everyone who helped crowdfund the cost of Mr. Wallace's lawsuit. Decastro even admitted he went to the federal building as a courier for Wallace to file this lawsuit. Once plaintiff's complaint was filed, Decastro went through the complaint online and continued to provide legal advice to his viewers on how to draft and file legal pleadings such as plaintiff's complaint. Decastro specifically advised his viewers on how to draft the caption, introduction, parties, jurisdiction and venue, and general factual allegations of the complaint if his viewers ever wanted to sue. Decastro further stated, "If they arrest journalists here, I'll seek them out and work with them and help them." The court should note Decastro is not a licensed attorney and therefore is engaging in unauthorised practice of law. It appears both Decastro and plaintiff have an axe to grind with LVMPD, and Decastro has assisted plaintiff in bringing a trumped-up, frivolous suit plaintiff will be pursuing vigorously. Where there was reasonable suspicion for plaintiff's detention and probable cause for his arrest, Decastro has not only been assisting plaintiff with his case, but also appears to be soliciting his services for any of his viewers who may be arrested in the future, which means this could be a continuous issue moving forward. Thus, the court should issue an order to permanently preclude Decastro from the unauthorised practice of law. Legal standard. Pursuant to 28 U.S.C. 1654, parties may plead and conduct their own cases personally. In an action brought by a pro se litigant, the real party in interest must be the person who has the right to be enforced. And a reference. Although a non-attorney may appear on his own behalf, that privilege is personal to him. Another reference. A non-attorney has no authority to appear as an attorney for people other than himself. Another reference. The Nevada Supreme Court, another reference, cited several general definitions of the term the practice of law, including the Ninth Circuit definition, in another reference, that the practice of law means the exercise of professional judgment in applying legal principles to address another person's individualized needs through analysis, advice, or other assistance. Another reference. Legal argument. The court should issue an order precluding Jose Decastro from practicing law without a license and providing unauthorized legal assistance in this case. Pursuant to NRS 7.285(1)(a), a person shall not practice law in the state of Nevada if that person is not an active member of the State Bar of Nevada or otherwise authorized to practice law in Nevada. A person who violates NRS 7.285(1) may be found guilty of a misdemeanor for the first offence, a gross misdemeanor for the second offence, and a Category E felony for any third and subsequent offences in the preceding 7 years, NRS 7.285(2). The overarching reason for requiring that only lawyers engage in the practice of law is to ensure that the public is served by those who have demonstrated training and competence and who are subject to regulation and discipline, none of which is applicable to a constitutional law scholar. An individual engages in the unauthorised practice of law when he performs activities customarily executed by licensed attorneys. Another reference. Some examples of activities constituting the unauthorised practice of law include evaluating legal claims, filing documents, and appearing in court on behalf of someone else. Nevada law makes it clear that giving legal advice and exercising legal judgment constitute the practice of law. Another reference. In another reference, the District Court of Arizona has to rule on a similar issue as the one described herein. In Sproul, the defendant, City of Surprise and Surprise Police Department filed a motion to preclude Amon M. Sproul from practicing law without a license. Defendants believe that Amon Sproul had been acting as an unauthorised legal representative for his son Amon Sproul II. Because it appeared that Sproul I assisted in the preparation of the complaint, the court determined that since Sproul I was not a licensed attorney, that he was precluded from practicing law on behalf of his son. Here Decastro is a self-proclaimed constitutional law scholar who has been assisting plaintiff by providing legal advice that attempts to address plaintiff's individualised needs based on the incident that occurred on May 10, 2023. The obvious similarities between Decastro and plaintiff's complaint demonstrates Decastro helped plaintiff draft a legal pleading, which is a function customarily executed by licensed attorneys. Moreover, Decastro has openly admitted to going to file the lawsuit on plaintiff's behalf. The Ortega Court has provided both of these services, in and of themselves, constitute an unauthorised practice of law. To take it a step further, Decastro openly discussed plaintiff's complaint online for his YouTube audience, informed them on how to draft and file the different sections of a complaint, which arguably is Decastro giving unsolicited legal advice to subscribers that view his channel. Decastro has even mentioned if any journalists found themselves to be arrested, he would seek them out to help them file a lawsuit. Therefore, it is clear Decastro has no intention of stopping with plaintiff, but intends to offer his services and provide legal advice to any individual who may find themselves in a situation where they believe they were wrongly arrested by the police. Thus, just like in Sproul, where the court granted the defendant's motion to preclude Sproul 1 from practicing law without a licence because it found Sproul 1 had assisted Sproul 2 in the preparation of his complaint, the court should rule the same here and grant this motion in its entirety. B. If the court finds Decastro has provided unauthorised legal assistance in drafting and filing plaintiff's complaint, the court strike the complaint as improper. Where a person is engaged in the unauthorised practice of law and filed pleadings in an action, the first appropriate remedy is for the court to strike the improperly filed pleadings. References. Consistent with striking the improperly filed pleadings, the plaintiff should also be prohibited from using any additional services of the non-attorney. Should he continue to do so, he would be leaving himself open to having more severe sanctions imposed. In addition, the Federal Rules of Civil Procedure provide the time for answering a complaint is extended by a motion under Rule 12. Another reference. Rule 12 includes motions to dismiss, Rule 12b, motions for judgment on the pleadings, Rule 12c, motions for a more definitive statement, Rule 12e, and motions to strike, Rule 12f. Since the instant motion includes a motion to strike under Rule 12f, the time to answer the complaint should be extended until the court reaches a determination on the issues. Furthermore, if the court determines Decastro has engaged in the unauthorised practice of law, then pursuant to Rizzolo, the first appropriate remedy is for the court to strike the improperly filed complaint. Additionally, if such determination is made, then the court should also prohibit plaintiff from using any of Decastro's legal advice moving forward. Then, if plaintiff continues to receive any legal advice or services from Decastro that are normally provided by a licensed attorney, then the court should sanction plaintiff for knowingly receiving such unauthorised legal services. Conclusion. Accordingly, LVMPD respectfully requests this court grant its motion to preclude Jose Decastro from practicing law without a licence and to strike the complaint as an improperly filed pleading in its entirety. At a minimum, this court should issue an order prohibiting Decastro from participating, assisting, or providing legal advice to plaintiff in this case. And signed by Marquis Urbach. Right. There are other motions in this case, but I'm going to stop there because I think this is the important one to get out now. And thanks for watching, and apologies for the interruption. That was my favourite soccer team mug. Oh well.